have a look at the registry of this land title?
Sure. Alright, please wait for a while. Alright, here's your key.
Okay, like Samut, I show you. This is room N17. Look at the toilet. Everything is perfect, very clean. Okay, so you see, this is the bedroom with the bed, everything, and also we have TV here with a very beautiful lamp and also a very nice view. And everything here is just for you and for you alone. So there's no one living here, and you can just take it now if you want. Yeah.
Seems good.
Okay, so these are all the terms of the agreement. So you can have a look at it in a little bit, then you can sign it. Yeah.
Is there any other thing that I should know? Am I the only access to the room?
Yeah, no problem, man. Everything is fine. You have the sole access to the room. Everything is fine. Yeah, you can have a sign here. Okay.
Okay.
Thank you. Nice meeting you. Thank you.
Can I use your toilet?
Oh,
come on, sister.
can. Come. You can use it every time.
My
anytime
toilet
you
flush
want.
is always not
Alright,
working.
don't worry, you can use it anytime you want. Just treat it.
Thank you so
treat it like
much.
your own.
Yeah. No problem.
Hey, excuse me, why are you here?
Who are you?
Oh my god.
The legal definition of land can be found in Section 205, subsection 1, para 9 of the Law of Property Act LPA 1925. It covers both physical assets and the rights that the owner or others may enjoy in or over it. Prior to 1926, land ownership was normally proved by the owner of land providing the title deeds. This consisted of an unbroken chain of the document transferring ownership of land, ending in a transfer to the current owner and going back over the minimum period initially of 16 years during the common law period, but reduced later to 15 years by the LPA 1925. The purchaser of the land was required to read these deeds because he was taken to be aware of their entire contents. There were a number of problems with the title deed system. It is plagued with danger even for the most conscientious purchaser. The reason behind this is that there could be a considerable number of deeds, particularly if the land had changed frequently. This created trouble for the purchaser when they try to ascertain whether any other person has rights or interests in that land. For instance, some of the deeds might be missing because they had been lost or destroyed, and where land was subdivided, there would be only one original deed forming part of the title to several properties. The reliance on the system of title deeds was not only cumbersome and relatively risky, it was also, for the purchaser, expensive to prove title due to the multitude of legal and equitable rights that could exist. In addition to this, an owner of equitable interest in that particular land might find his interest destroyed by a simple sale to a purchaser who was unaware of its existence. In the case of Williams and Glyn's Bank Limited and Boland, Lord Scarman commented that this system involved the wearisome and intricate task of examining title. In order to overcome the problems of the title deed system, the Land Registration Act LRA 1925 was designed. It inaugurated a fundamental change in the land law in England and Wales. LRA 1925 aimed to bring certainty where there was obscurity and also bring equity when there was often inequality. A register maintained by the land registry records details of the land, including information about its physical extension, who is currently the owner of it, any rights which exist for its benefit, any mortgages to which it is subject, and any other encumbrance of or burdens to which it is subject. In verifying whether the seller has the right to sell the land, instead of checking through a chain of title deeds, all that a purchaser needs to do is make a simple check with the land registry. Lord Oliver, in the case of City of London Building Society and Flat, commented that the LRA 1925 was introduced as part and parcel of the overall property legislation enacted in that year, and also it introduced for the first time a power in central government to designate areas in which registered conveyancing would be compulsory. It is notable that the LRA 1925 was replaced by LRA 2002, which provides a further explanation of the number of situations in which registration is compulsory. Section 1 of the LPA 1925 defines those rights that may be legal. Nonetheless, the rights must be accompanied with proper formality, which is the requirement of deed and registration in order to be legal.
From the question above, it can be seen that the statement reflects mirror principle. So, what is mirror principle? Basically, in 1963, there are three fundamental operating principles of registered land laid down by Theodore Rolfe, which are mirror principle, curtain principle, and insurance principle. First, we will look at the curtain principle. In this principle, certain equitable interests in land should be hidden behind the curtain of a special type of trust, which also known as equitable interest behind the trust. If a person wishes to buy registered land that is subject to a trust of land, the purchaser need be concerned only with the legal title to the land, which is held by the trustees. He need not look behind the curtain of the trust or worry about equitable rights of ownership that might exist. Any such equitable rights will be overreached by the purchase money that the trustee will get for the equitable owner. The main point is to facilitate the annuality of land by freeing the purchaser from the effort and worry of dealing with equitable owners. Next, in the insurance principle, if a title is duly registered, it is guaranteed by the state. The state insures against inaccuracy or other mistakes in the register. For example, if A is the true freehold owner of the land, but B is registered with the title by innocent mistake, and then C buys the land from B on the basis of his registered title as guaranteed by the LRA 02, it is obvious that either A or C will suffer by reason of application of the registration system. The insurance principle stipulated that a registration system must provide compensation in such cases. The third principle that we will talk about is the mirror principle, which is also considered as the most important principle in answering this question. In this principle, the registers should be a mirror to reflect all proprietary rights, which are both estates and interests that exist in any given piece of registered land. Thus, the register should amount to a comprehensive picture of the land for any prospective purchaser. The point is simply that if the register reflects the full character of the land, any purchaser and any third party can rest assured that they are fully protected. The purchaser knows what he is buying, and the person with an interest in the land knows that he will be protected. However, it is sad to say that the register of title is not a perfect mirror of the title to a registered property. It is impossible to rely on entries on the register as the complete record of everything that affects the title. And this can be seen in the case of Overseas Investment Ltd. Sincobuild Construction Ltd. The objective of the mirror principle has not been met under the LRA 02 because of the impossibility of entering all land details in the registry. And unfortunately, the LRA 1925 was failed to eradicate all cracks in the mirror, instead preserving the relevance of certain interests which may override registration. Unregistered interest which may override is also known as overriding interest. It is a category of rights which affects the land and which bind any transferee or purchaser without even being entered on any register that compromise the status of the mirror principle. Overriding interests are not a mistake. It is impractical to make absolutely everything subject to express registration and cracks the mirror. The purchaser always needs to inspect the land to make sure that there are no adverse rights over the land. With the registration of land and the inspection of land, the LRA 202 succeed. This overriding interest burden registered land by operating on a superior plane to other registrable interests, binding purchaser outright and disproportionately empowering the overriding interest holder. Under the former law, the class of overriding interest which caused the most litigation was contained under Section 70, Subsection 1, Subsection G of the LRA 1925. This subsection protected the rights of persons in actual occupation of the land or in receipt of rent save where inquiry had been made of them and their interests had not been disclosed. Most disappointingly is the existence of overriding interest, which remains today, will continue to deny the mirror principle. It is still not yet considered as a perfect reflection of reality. Hence, it can be said that the mirror will only be a perfect reflection when all proprietary rights that exist in any given piece of registered land was registered on the registry. And yet, this will consider the role of e-conveyancing. Next, it is clear that the mirror principle is still not fully entrenched in the England and Wales system because of the existence of the overriding interest, which will be discussed more in depth by my friend.
Unregistered interests which override are those rights in another person's land that have priority to the registered title of the registered proprietor. They are binding even though they have not been entered on the register of title of the land they affect. They are able to exercise the right against the land irrespective of who is the registered proprietor and even though it is not in the register. Schedule 1 of LRA 2002 is about the interests which override at first registration, and Schedule 3 concerns interests which override following a transfer of land that is already registered. Schedule 1 is wider in scope and Schedule 3 is less extensive. Overall, the LRA 02 has reduced the power of overriding interest in both schedules to ensure that a potential purchaser is bound only by those unregistered interests, which for practical reasons that the purchaser had a realistic opportunity of discovering the existence of the interest by a physical inspection of the land or by making normal inquiries of the transferor. Overriding interests were a cause of concern to the Law Commission and Land Registry when devising the LRA 02, but their social and economic importance is such that they cannot be dispensed with. However, the LRA 02 can reduce the impact of overriding interests to reduce their number and to encourage their entry on the register. Schedule 1 Para 1 is about short-term leases. Legal leases originally granted for 7 years or less will override at first registration. A tenant in a short-term lease is likely to be in possession, and so his lease will be easily discoverable by an intending purchaser of the land and hence perfectly acceptable as an overriding interest. Schedule 3 Para 1 is identical with Schedule 1 Para 1, where it will bind the transferee automatically. Schedule 1 Para 2 covers the interest of person in actual occupation. It should be noted that first, there is no protection for the interest of persons in receipt of rent and profit of their land. Second, the enforceability of the interest protected is now to be limited to the land actually occupied by the interest holder. Third, there is no qualification relating to disclosure of the interest as there is in relation to Schedule 3 as that was under the old law. This means that a person claiming of overriding interest under this paragraph must prove that he holds a property interest in the land that is about to be first registered and that he is in actual occupation of that land at the relevant time. In the case of AB, the House of Lords had held that the relevant date of determining whether a person is in actual occupation is the date which the disposition is executed, not the date on which it is registered. In Mallory and Cheshire Homes, the claimant established actual occupation through acts of minimal use, particularly the erection of a fence around the plot to keep out intruders. Schedule 3 restricts even more than Schedule 1. Schedule 3 Para 2 further explains that the third-party interest will still take effect through actual occupation as an overriding interest if the transferee has actual knowledge of the right. Schedule 3 Para 2b expressed that an interest will not override if inquiry was made of the right holder and he failed to disclose the interest when he could reasonably have been expected to do so. Thus, the inquiry must be directed towards the right holder of the interest, and it is his non-disclosure that is the key. Schedule 1 Para 3 comprises legal easements and profits. They must be registered as land charges or they will be considered void. Furthermore, in Schedule 3 Para 3, it is shown that fewer easements and profits will override a registered disposition that will a first registration. A legal easement will override, but only if any one of the following conditions are satisfied. The easement is registered under the Commerce Registration Act 1965. The legal interest is within the actual knowledge of the transferee. The interest would have been obvious on a reasonably careful inspection. The person entitled to the benefit of the interest proves that it has been exercised in the period of 1 year ending with the day of the disposition. Section 71 of the LRA 02 provides for a general duty of disclosure whereby an applicant for registration of a title must disclose a range of overriding interests that affect his land so they may be protected by registration. In consequence, the group of interests that override under the LRA02 will shrink as more and more of these rights become protected by an entry on the Register of Title, and thereby are revealed to a prospective purchaser of the land. Interests should be overriding only when it is unreasonable to expect them to be protected on the register to protect the parties in some circumstances.
Overaging is a mechanism aimed at achieving conveyancing efficiency with minimal regard to protect the interest held in land. It can examine that the overaging applies where there is an existence of the trust in land in both registered and unregistered land. Overaging is a process by which the rights of the beneficiary under a trust of land become detached from the land on conveyance and attached to the proceeds of the sale. Therefore, a person holding only beneficial ownership can be said to have rights in the value of the land rather than the land itself. In most of the situations, those with equitable ownership rights will also hold legal title, so overreaching will not be a problem, since a conveyance of the property will require consent. However, difficulties always arise where the beneficial owner does not have the legal title, as the trustees may convey the property without their knowledge or consent. As far as I'm concerned, overreaching ensures the purchaser of land takes the property free from any beneficial interest and applies irrespective of the notice, meaning that it favors the interest of the purchaser over that of the beneficial owner, and it is capable of producing a just result. It is important to understand that overreaching in the context of the land registration system. Under Section 4, Subsection 2 of the Land Registration 2002, the legal titles capable of substantive registrations are fee simple absolute impossessions, and leases which at the date of creation, of transfer or creation have more than 7 years to run. Where overreaching has occurred, the interests of the beneficiaries are not lost but attached to the sale proceeds received by the trustees instead of the land. The equitable interests are converted from interest in land to interest in money. This enables the land to be sold free of the rights of the beneficiary. However, if there is only one trustee, then the trust cannot be overreached, and the purchaser must deal with the beneficiaries. Thereby, the Cartan principle cannot apply on here. Where a purchaser has not overreached the interest of the beneficiary under the trust, because there is a sole trustee, the buyer will be bound by the trust interest unless he is a bona fide purchaser for value without the notice of the equitable interest. The notice may actual, constructive, or imputed. The same situation applies to unregistered title as demonstrated in the case of count and cons. Under the third principle of the insurance, the state guarantees the accuracy of the register, and compensation is payable to a person who suffers a loss of errors made by the land registry. The law protects the interest of the third-party purchaser provided that they have paid the purchase money to two or more than two the trustees. The purchaser who has not done is vulnerable, but in this situation, overreaching would not occur. These concerns were sufficient for the Law Commission proposal to be made to make the position fair, especially to a beneficiary in occupation.
LRA02 purports to require the registration of as many proprietary rights as possible that affect a registered title. As much of the Act is driven by implementation of the efficient system of e-conveyancing, it is undeniable that an intended transferee of the land, particularly a purchaser or mortgagee, should be able to discover as much as possible about the adverse property rights from the inspection. Thus, the Act makes the registration process for third-party rights simpler and punishes the non-registration by a loss of priority against the duly registered transferee for value. Third-party interest usually refers to the rights of persons other than the owner, such as lease, easements, and restrictive covenants. Means were provided whereby most third-party rights can be registered, not only for the benefit of the potential purchaser to discover the rights behind the trust, but also to enhance the protection afforded to third parties who have an interest over registered land. Third party must make sure that their rights are registered to ensure their priority against a prospective purchaser, because if it is not registered, it might amount to overriding interest. The registration of third-party interests under the LRA02 is relatively simple compared to that of 1925 Act.
third-party interests can be protected on the occasion of a disposition of the registered title, either by a conscious act of the registration by the right holder, or silently by the reason of the interest falling within the ambit of our overriding interest. The former involves the protection of third-party interests by the entry of notice, and the latter involves the use of restrictions. There are two types of notices, which are agreed notices and unilateral notices. The circumstances in which the registrar may approve an application by a third party for an agreed notice is set out under Section 34 of LRA 2. Section 34 subsection 3A and B are cases where the relevant registered proprietor has actually consented to the entry of notice, whereas subsection C covers the position where the registrar is satisfied as to the validity of the applicant's claim, and in such circumstances, the registered proprietor's consent is not required in the registration. On the other hand, the entry of unilateral notice on the register is governed under Section 34, subsection 2b of LRA02. It provides a large degree of protection to a third party. The application does not require consent, but the applicant must satisfy the land registry with some evidence that the right exists. A registered proprietor may move to cancel the notice, and the beneficiary will be notified and given an opportunity to object. The registrar must cancel the notice if the beneficiary does not exercise his right to object. Restrictions confers protection of third-party interests indirectly by controlling dealings with the title, and thus limiting the circumstances in which a transferee may claim priority through registration as the new proprietor. It ensures that there will be no dealings with the registered title until the conditions specified in the restrictions are complied with. Further, for those interests that cannot be protected by entry of notice at all, would be appropriate protected by the entry of restriction. For instance, beneficial interest under a trust of land, a leasehold for 3 years or less, and restrictive covenants made between lessor or lessee relating only to the leased premises. All in all, the LRA02 tries to balance both competing interests, which are the prospective purchaser and third-party rights holder, and achieve it through the medium of register rather than by other informal mechanisms such as overriding interest. The requirement of duty of disclosure along with the registrar power to enter notices, and the reduction in the number and extent of overriding interest, the Act can be regarded as providing the efficient and effective deliberate protection of third-party interests in registered land.
In the trajectory of LRA02 in executing total registration of conveyancing process, the governance crack in the mirror was certainly something that was never intended by the Law Commission, particularly the hurdle as evident in the case of Abbey National and Kent concerning the confusion of priority between overriding interest and mortgage yet to be registered. Thus, LRA02 with its dynamic furtherance of e-conveyancing purports to eliminate such gap by emphasizing synchronicity between disposition and registration in land transfers. Whilst applaudable progress such as introduction of electronic discharge and also land registry portal has been made, Section 91 of the Act nevertheless remains a preparatory step which in fact needs to be coupled with passing of statutory provisions further approving the usage of digital signature in electronic funds transfer service, and also accrediting better security of exchange of e-documents and data for e-conveyancing to realize its initial intended vision. However, it is also noteworthy that the 2017 update unfortunately seems to suggest a removal of the requirement of simultaneous completion and registration, but instead moving forward with a view to developing a more gradual introduction to complete electronic conveyancing today. Further scrutinizing the trump card of overreaching procedure available in the hands of purchasers, the law indeed offers blatant protection towards them against equitable interest under a trust as long as proper formalities under Section 2, subsection 1, para 2 of the Law of Property Act 1925 are adhered to. However, in reality, it is seen that the requirement of such payment of capital money towards at least 2 trustees and predominantly trust corporations indeed involves an exorbitant sum. Thus, this causes the protective mechanism to be rarely embraced by purchasers. And not only so, on the other hand, it was also clearly demonstrated in the case of City of London Building Society and FLAG that overreaching could also be particularly harsh on beneficiaries, even if they have been in actual occupation of the mortgage property. Therefore, it appears that a fine balance has to be struck between both interests of purchasers and third-party beneficiaries, in which this could in fact be best attained by extending the currently limited consent requirement by the court under Section 14 of TOLEPA to stricter legislative provisions. Notably, the other safeguard of asserting inquiry before disposition against any overriding interest, which enshrines the maxim of caveat emptor, may nevertheless also operate in averse towards purchases in circumstances where physical inspection of property is impossible. Thus, this places a heavy onus upon solicitor and buyers in ensuring sufficient professional insurance is adopted. Besides, even if full character of land is reflected in the register, no guarantee and satisfaction that the register indeed holds accurate and trustable information deems it becomes rather futile in that sense. Thus, Law LRAO2 has taken measures in assuring that such guarantee is given via Section 28 of the Act and its reinforcement of indemnity in light of the insurance principle. Nevertheless, identity fraud, which would in fact actually defeat the whole purpose of registration, has also been a hot topic addressed by the Law Commission lately with its latest consultation paper considering a shift in burden of financial consequences of fraud from the land registry towards conveyancers and mortgage lenders who do not conduct their business appropriately, hereby tendering unabridged protection towards both property buyers and also third parties.
In summary, land reform legislation, particularly the Land Registration Act 2002, have indeed augmented and endorsed registration of title to title by registration in English land law. Nevertheless, perfection in attaining total registration reflecting full character of land is in fact still far from reality, as despite possible efforts in diminishing categories of overriding interest along adverse possession, such interests still perpetuate within the domain, hereby rendering partial protection to property buyers only. Same goes with the position of third parties whom, although via entering of notice and restrictions, have their interests protected, their equitable interest capable of being overreached despite its conversion to monetary interest may in fact still infer that full protection has not been accorded to them as well. Thus, extensive reforms have indeed been called upon by the Law Commission in further shaping the land register into a more remunerative mirror operating alongside e-conveyancing in this digital age.